We have one case on the docket for oral argument this afternoon, the case of Tarantola versus Henghold. Counsel ready to proceed?
Yes, sir.
You may approach counsel. Counsel allocated 15 minutes per side for the oral argument. Would you like to reserve some time for rebuttal?
2 minutes for rebuttal, Your Honor, if I could.
So noted, Madam Clerk.
Good afternoon, may it please the court. I represent Dr. Tina Tarantola, who is a dermatologist Mohs surgeon in the Pensacola area. She worked for the Henghold practice beginning in 2012. Her last day at the Henghold practice was March 16th, 2015. I stand before you 3.5 years later, while she is still subject to a temporary injunction seeking to enforce a 24-month or 2-year covenant not to compete. My position is under any set of circumstances, any analysis we want to do it, this thing is over and has been over for a long time. The court entered, and this is...
If I could ask.
Sure.
What remains below? In other words, this appeal, I know there's 2 others pending.
Yes, sir.
Is there anything else pending in the trial court claiming that Dr. Tarantola is in violation of this covenant not to compete?
Well, she's still under the temporary injunction. The injunction, yes, sir. Besides that, no. I have counterclaims, and we have to go to a final hearing on this, which is not even scheduled yet. I think we're a year away from a trial on this case.
And what would that trial look like?
The trial would look like whether or not my client should. I think what we're down to now is because I think she's served the 24 months. So if in a temporary injunction you go for a while and maybe there's 6 months left at the end, you get a permanent injunction for the full 24 months. Here we've blown way past that on the temporary stuff. So they're not entitled to any more than 24 months. So the trial would look like my counterclaims, and then I've already proven that my client was wrongfully enjoined for the dermatology part that we got reversed from this panel on my first appeal.
Factual question on that.
Yes, sir.
How long was she precluded from practicing general dermatology until our court issued its ruling?
Off the top of my head, it was a long time. It was 8-9 months, something like that, Judge, something like that. I'm not telling you exactly because I would go back and calculate it for you, but we went through that whole process before you.
Was that at all included in the trial court's analysis of whether to extend this injunction or not, or whether to?
No, Your Honor, no. Okay. And again, because really because the original temporary injunction, which has been modified subsequent to the second appeal I had for the motion for contempt, the temporary injunction never had an ending mechanism. It didn't say until further order of this court, nor did it say it ends on this particular date. So it just left her enjoined. So I filed a motion to terminate the injunction in an effort to get the court to terminate, because under my analysis, we were close to the end by that point under any set of circumstances. The original temporary injunction was for approximately 17 months. The court says that in its original temporary injunction. How does it get to 17 months? Well, my client left the practice in March of 15. She went to University of Florida in Gainesville to do locum tenens work. Then she had a second baby in July of 2015. She saw her first patient, because I believe we're eventually going to get out of this whole thing on stuff like that, but she saw her first patient. It is now totally clear she could see general dermatology patients anywhere on the planet. She saw her first patient October 12th, 2015. I went March 16th to October 12th so that I could avoid having to do this.
Factually, there's no evidence that shows that she's performed any Mohs surgery within the restricted area. Is that correct?
Absolutely right.
So this is all about
advertising.
This is all about advertising and marketing.
That's how the court came.
All the litigation, pretty much, is.
I think it has come down to that now. It has become a definitions in Black's Law Dictionary. What does advertising mean? What does marketing mean? The court's gone back and forth on that, said they're different things. Now they're the same thing. But we've gone through that kind of a process.
And we're here today because the trial court refused to terminate it, finding that there was this website purportedly advertising or marketing surgery
right.
during that time period, right after she left the employment of Henghold.
Yes, sir.
When she was at Gainesville or something. I mean, it's
University of Florida.
That's what we're here today about.
Yes, sir. the court, and that is error in any number of ways that I've explained to the court. Number one, there's no competent substantial evidence to support that. Number two, even if that is evidence, it doesn't support what he needs to say. The court made no findings about public policy, and then this is a separate appeal, but it applies here as well. The court, in extending this temporary injunction, refused to increase a bond that's supposed to protect the person who's enjoined. So
Right.
those four reasons.
Counsel, we're here today on this order, and most of the order deals with an analysis of this 2015 website, which never was introduced into evidence. It was attached, quite frankly, and look at reading every word of the January hearing, it's not even a subject matter of any testimony or oral argument. It then arises in the bench briefs, and the copy of the website's attached to those briefs. Opposing counsel is arguing that because you didn't file a motion to strike or didn't raise some form of more aggressive objection for it to even be considered, that any argument that it's not in evidence has been waived. How do you respond to that?
You have to have an affirmative waiver of this. I have had, it's not hundreds, scores of intellectual discussions with the court in this very case on any number of issues about look for this, look for that. The court in this case literally looked at my client's present website during the hearing and said, how about that? And we had an intellectual discussion about all of this. My position is, Your Honor, that even if that is in evidence, it's not dispositive of anything, it doesn't support that. At the very least, the date on the web is October 14th, 25th. I was arguing use October 12th. So even if they're saying this is somehow a violation, I was saying use 2 days earlier to get to the point. If you find that that's a violation, this injunction was over on February 8th, 2018, not February 10th as I originally argued.
So any interpretation by the court that this website was up in May, even though there was a date stamp, in October, whether it was or was not in May through October, is mere speculation. We have no testimony on it.
Absolutely, and my client testified under oath at the hearing. The evidence that I produced for October 12th, October 28th, when she left and stuff like that, is evidence that I adduced when she was on the witness stand. They had two lawyers there. No one asked her any questions about this stuff. Then they go back and they try to say, oh, look, on your Facebook page it says this. Okay, well, that's not, none of that is anything. You are absolutely right. It's pure speculation whether this thing started in May at all. There's no evidence that it started in May. This thing is not in evidence, and even if it is in evidence, my argument was 2 days later anyway as a result of that to stop the injunction. Then the court goes on in the order and says that the injunction should run at least an additional 134 days from the date of this order. I cannot tell you how the court arrived at 134 days from the date of the order, which is just another date in the file. There is no way to tell from that order how the court arrived at 134 days. I can't get to it. I know this thing backwards and forwards. I can't get there. All I can do is say that January 23rd was a date that was in the appellee's brief as to a date that might be an end date because of what they went through on stuff like that. I just think the court went back and said, January 23rd, how many days is that from the day I'm going to sign the order, and that's what I'm going to put into it. There is no other way that I can get to 134 days. If you read this thing 100 times, you can get to no analysis that the court comes to add 134 days to this injunction. You can't get there from there. I don't know how you did it.
With respect to the winding down, the 30-day period, the trial judge found that that should not be credit for the doctor. In this case, am I correct in interpreting the record that during that wind down period, this was pre-issuance of the temporary injunction, that the doctor was performing Mohs in the restricted area before entry of the temporary injunction? So during that wind down stage, she was performing Mohs surgery.
That is correct.
Okay.
But there never should have been a wind down anyway. We know that now. She was actually forced to close her entire practice, which we know after the appeal should never have happened. She should have at least been able to continue to do general dermatology in the building. Now, they've argued that this is some kind of benefit from her for doing Mohs because she got money for it and things like that. Well, she had to keep a place open. She had to keep people employed that was closing because she had to shut down her entire practice after that injunction. There was never a need for a winding down period.
Well,
Now,
even if we ruled against you on the wind down period and added that 30 days to the February date you're asserting should be the cessation date, we'd be past.
You would be past that at
The
all.
injunction would be over.
That's right. And-
Regardless.
Absolutely right. And because I tried to do this as conservative as I could, so I did not have to stand in front of this esteemed panel later on, I used the October 12th date. The date under evidence is October 28th. That's the first day she did Mohs surgery in the restrictive area. If you use that date instead of 12th, it's January 25th. And that is my position today, is that, look, that's the evidence that we adduced at the hearing. I argued it originally before the court came back with its second appellate ruling. The actual date this thing is over is January 25th, 2018. January 25th, 2018. And that is absolutely without a wind-down period.
Yeah,
The court
exclusive of wind down.
exclusive of wind down. If you rule against me on the wind down, it's 30 days from that, February 28th, 2015. That's when it should be over under any set of circumstances along the way. Interestingly, on that, the court looks at January 23rd. That's the date that you get if you just add the 134. If you look at Appleby's brief, they say, well, that's really not the date because you got to add 30 more days to it, so you get July 23rd. If the court used June and in his order said I don't get credit for a wind down, he should have made it July if he was trying to do that kind of stuff right, if you see what I'm saying. Because he agrees with them that the wind down should not be a credit to me, but then uses their date that doesn't include the wind down along the way. That is my speculation as to how this stuff happens. I think it's error. You can't figure it out from here. That is not evidence. Moreover, there's no explanation about public policy at all. The court has a requirement.
Regarding your public policy argument, counsel, support of the motion to terminate the injunction, what record evidence indicates there's a deficient more surgeons in the restricted area?
Yes, sir. I provided that the two other Mohs surgeons who were at the practice resigned during this time frame, such that the Henghold practice went from 3 to 1 Mohs surgeon within the restricted period. We've had, 7 or 8 evidentiary hearings. In one of my hearings, in a motion to dissolve the injunction, as I was trying to get this, time rolls on, I'm 24, I'm 3.5 years down the ride here, we had a motion to dissolve, and during that motion to dissolve, I called witnesses, both the former directors of nursing of the practice, as well as an investigator from the Department of Health, who issued a cease and desist letter to the Henghold practice saying that this nurse should stop practicing medicine. I had the directors of nursing say that nurses were doing surgery in that practice. I think all of those are public policy violations in addition to the 2 other surgeons leaving the practice at the time. This is a 40-mile radius. It's a small community, Mohs surgeons. And again, you don't have to be fellowship trained to do Mohs surgeons. My client is fellowship trained to do Mohs surgeons. So was Dr. Henghold. So were the 2 who left, were fellowship trained. It's a specific fellowship in dermatology that you go through. I think all those things were there. And again, my position is it's not my job to prove that it violates public policy. It's the court's obligation to say that it doesn't violate public policy. That's what the statute provides. That's what the case law provides. When you're doing this type of temporary injunction, it has to not violate public policy. It's one of the 4 findings you have to make to do that. If you're extending it 3.5 years for a 24-month covenant, I'm of the position that the court had to do some kind of analysis there. The court doesn't even mention it along the way. And I don't believe that it's my burden to come back and say, well, it violates. I certainly think it does. I think the court has the obligation to say it doesn't violate. And along the way, that the court never mentions it along the way. Also, the bond. This is subject of something else, but the court extends it for 5 months.
In reference to the bond,
Yes, sir.
counsel, that is specifically in reference to your motion to increase the injunction bond, the appellant challenged the setting of the initial injunction bond?
No, sir. The $1.2 million bond, I did not challenge based on a number of factors along the way.
And how does that affect your argument today?
I think it does not at all, because the court, sua sponte, at the hearing, said on the record that he used lost income, potential lost income, in our original hearing. I brought an expert, Marvin Beasley, economist, who said it was $3 million of lost profits damage. The court then switches his mind at the hearing and says, I should have used lost profits, not lost wages. And I'm like, okay, it's $3 million. And he's like, no, and he comes back with the same number. I would submit to you that I'm choosing this word carefully, it is impossible for that number, using the wrong analysis, wrong evidence, and everything else, to remain exactly the same. Impossible for that number to stay the same. And I'm into my time right now. If there's any other questions, I would like to reserve the last 1 minute 25.
Counsel, in view of the arguments that have been raised and the questions asked of you, we will extend your time by an additional 2 minutes.
Thank you.
We'll also extend counsel for the appellee's time by an additional 2 minutes as well.
Thank you, sir.
continue, counsel.
Thank you, Your Honor. May it please the Court, my name is Trevor Thompson, and I represent the appellee in this case, William B. Henghold, MD, PA. I'm going to simplify that for the purpose of this oral argument as just Henghold, because it's the business and not Dr. Henghold personally. This case is about, in broad strokes, the efforts by the appellant to foist its evidentiary burden onto Henghold and onto the trial court, and to criticize both Henghold and the trial court for failing to prove things that we were not obligated to prove. And this court should affirm for three reasons. First, the appellant failed to meet its burden to show that it was entitled to credits. This was a two-year restrictive covenant, a two-year non-compete, and the bond for the injunction was entered on September 8th, 2016. So when appellant comes up and says, well, this has been 3+ years, that ignores the fact that there was a period from October 12th through September 8th of the following year that was treated as not in compliance. So some of this time is a little bit overstated. The 2-year period would have expired.
When you say it was not in compliance, how was it not in compliance?
The evidence that was presented in seeking the injunction was that Dr. Tarantola was performing most surgeries through the Tarantola dermatology entity.
These were the follow-up? Or were these the follow-up from the time she was at Dr. Henghold?
Yes, this was the first opinion in which this court upheld the injunction. The evidence was that she had opened the business, and she testified directly that she had opened up the business because she was under the opinion that the non-compete provision was unenforceable. And so she directly and willfully violated it with the belief that she would show up in court and the court would not uphold that.
So, well, that's where I'm getting confusion in my mind. I thought that initially she was practicing general dermatological medicine and that she got shut down by the injunction because it was overbroad. Wasn't that the case?
It was, Your Honor. And though it was overbroad, she was performing both general dermatology and Mohs surgeries. One of the things that appellant stated up here, which I don't believe is disputed, is that she conducted her first Mohs surgery on October 28th, 2015. And while she wasn't necessarily doing them every day, I don't believe there's evidence to that effect. The understanding is that she was performing Mohs surgeries through the end of 2015, through 2016, up through the point at which the injunction became effective, potentially with an extension based on the wind-down period.
And these were in the restricted area, not in Gainesville?
Yes, Your Honor. When she first opened her practice, it was in Pensacola only. And it was in response to the injunction that she opened up 2 additional offices in Florida, and she opened up a 3rd office in Fairhope, Alabama. The Fairhope, Alabama office, to our knowledge, and I believe the evidence so far, is the only place in which Mohs surgeries have been performed outside or after the injunction was entered. Yes,
As a follow-up to Judge Baker's earlier question, what is left for the trial court to currently resolve regarding the complaint that was filed alleging a violation of the appellant's employment agreement?
Your Honor, we believe that that the order that's under review leaves open the question of when there would be a proper termination. This has been complicated somewhat by the automatic stay that's imposed by the petition for writ of certiorari in the recusal case, which is pending before this court. I can't say that I've calculated the effects of that proceeding, but when the trial court in this order that's under review says at least 134 days, and potentially more because of the wind down, the trial court is basing its judgment on relatively little evidence. And there's nothing truly definitive in this. For example, this is non-final to the extent of if Dr. Tarantola were to come before the court and say, look, the website was operational in July, but it wasn't operational in May, that would surely affect the evidence before the trial court, and the trial court may come and reduce the additional credits. It may choose a date.
If I understand your arguments correctly, you're almost saying there's a burden of proof issue here, that it was their burden of proof to come in with this motion and to show that their website was not violative. Well, they came in to say, look at the chronology, look at the calendar, the temporary injunction should be over. Am I not mistaken that you're the one, or your client's counter argument was, no, it's told their website is non-compliant. That would be your burden to prove.
Your Honor, there are 2 aspects in answer to your question. The first aspect is that the 2 years would have expired on September 8th. So to the extent that Dr. Tarantola shows up in court and says this should be terminated on February 10th, she is asking the trial court to affirmatively establish that she was in compliance for a particular period. And what is offered is, well, she was terminated from employment on March 25th, move that forward to October 12th or October 28th, depending upon the standard. And the only time, the way in which the motion itself phrases it is in a footnote. It says the only time conceivably that the injunction could have been violated is when she opened her doors. And so it's premised on a legal argument which is incorrect, which is that the employment agreement has multiple provisions that she could potentially be in violation of. And she could do
So if she waited for 2 years and didn't practice any sort of medicine for 2 years, then open up an office, your position is that the 2 years would then start running at that point?
No, Your Honor. If she were able to adduce evidence to the court that she did not practice Mohs surgery for 2 years, that would be full compliance. But when she comes to court with a 2-year period that's supposed to end on September 8th, 2018, and says, look, I was in compliance for 134 days, and she has no evidence that she wasn't advertising, she has no testimony that she was obeying any of the other restrictions, any of the other covenants, the only thing she says is, yes, I started violating the practice restriction on October 12th. That's insufficient to meet her burden of proof.
Well,
to
it's
claim
your
the
breach
credits.
of contract argument, though.
Excuse me?
She doesn't have to come in and prove I've complied with every provision. Isn't it your burden of proof to come in and say she breached the contract as follows, and here's the evidence to support it? If not, the time runs.
We believe that the burden to modify or dissolve an injunction established by the Planned Parenthood case cited in the briefs places that burden on her. To the extent that she wants to claim credit over and above the flat 2-year running of time from the September 8th, 2016 effectiveness of the injunction bond.
Well, isn't it mutually exclusive for you to argue that, no, it's her burden because this is a modification, at the same time you're arguing in your briefs that the law of the case doctrine doesn't apply, that we've never addressed these issues before? So that's a mutually exclusive to me. Those are two different positions.
Your Honor, our argument is that the law of the case is specifically confined only to the public policy argument, and it's based on the premise that when this motion to terminate was presented, there was no public policy argument presented. It was solely presented as, look, these 210 days of compliance should be counted against the 2-year period. There was a minor public policy argument raised in the form of the 2 resignation letters in the bench brief that was filed the day of the January 29th hearing, but that was the only policy argument that was presented to the court. The colloquy that exists on roughly page 715 or 716 of the initial brief appendix up through the beginning of Dr. Tarantola's testimony, which begins the argument on the injunction bond motion. All of that is legal argument having to do with the law of the case effect of the Tarantola 2 opinion and the effect of the website. There is no argument as to public policy as presented there. And so there are only 3 forms of evidence that were asserted in this appeal that public policy needed to be addressed in the order. The first was the 2 resignation letters. Those were never admitted into evidence, so to the extent that that appellant wants to fault us for not putting in the website evidence, that was their practice as well. They did not put in the resignation letters. They were merely attached to the bench brief filed that day.
I'm not sure I give a lot of merit to the public policy argument. So could you address your thought process on the website, whether those documents should be in evidence and whether that's properly before us when it wasn't authenticated, it wasn't introduced?
Your Honor, we did not formally introduce it. There is authority in this court. State versus Caldwell, that's a 1980 opinion, and that's at 388 Southern 2nd 640, pin site 641. It's dealing with an attorney's fee motion in which the affidavit of attorney's fees was present and was discussed by everyone, but was never formally introduced and was treated as though submitted by the parties through their discussion. And the court said that that was sufficient for the trial court to consider that. It nevertheless held that the affidavit, even though properly considered, was insufficient to support the order on appeal.
Here we're restraining trade for a very much needed service. Isn't that a little bit different? And here you're saying a document not even entered into evidence ought to be able to prevent this physician from providing the surgery for another 134 days.
Well, in addition to the argument based on Caldwell that it's possible for the court to consider that, it needs to be contextualized in the facts of the case, which are that there was a substantial over 40-page record discussion about the website. And while the trial court looked at the present version of the website, the trial court was also looking at the website that was submitted as
But
part
counsel, what evidence supports the trial court's conclusion that the website was used or posted in May of 2015?
The trial court can basically take a bunch of information which was presented. Much of it, those that were attached to the response to the motion, were not formally introduced, but were also not the subject of any contemporaneous objection during the discussion about the website. For instance, there is the May 15th Facebook posting in which Dr. Tarantola announces her website. Part of that post indicates the same language that's found in the Contact Us webpage that was also submitted. It says that she's currently on leave, she's going to be opening up soon, and she invites prospective patients to contact her to set up an appointment. As has been indicated, Dr. Tarantola left the University of Florida in July of 2015 when she had her baby. The basic information presented on this website, even if one cannot pin down a date, is that she put this website up in advance of opening her office. And what the record evidence showed, at least in securing the injunction, and this goes back to this court's evidence before the court in the Tarantola 1 opinion. You'd find this in the briefing, at least in one footnote, not the actual evidence, but the evidence that has been presented before the court in securing the injunction is that when Dr. Tarantola opened up, shortly thereafter or contemporaneously, there were over 24 record requests from former patients. It's clear that this effort to reach out actually succeeded.
Getting past the admissibility issue in terms of the website, let's assume for the sake of argument that the website is admissible and the evidence establishes it was in existence in May of 2015. How does it constitute improper advertising in violation of the non-compete argument?
Your Honor, we believe that unlike the contempt-based order in the Tarantola 2 opinion, in which the argument was that the injunction's provisions were not clear and didn't provide a directive to Dr. Tarantola, the website here, both the factual and the legal context, is sufficient to view that as a violation of the restrictive covenant. We believe it's clearly advertising because it acknowledges the services. It does not say she is providing Mo's services quite that plainly, but it does provide that information in a way we believe is clear to any reasonable observer. When she says that she is a dermatologist and a Mohs surgeon practicing and treating patients in the Pensacola and Northwest Florida region, that puts a very clear and definitive idea into the mind of the reader.
How is that any different than a resume? You know, if you looked up our bios, there's many things we've done in our legal careers in different specialties, but we may put that on the resume, but it doesn't mean I'm currently practicing that, or if I'm board certified in a certain legal specialty, it doesn't necessarily mean I'm practicing in that area. So how is that different than bio information?
We believe that rather than being set apart in a separate biographical page, and there is an about page that was put on, a purely biographical page. This is the front page of the website that says she's a Mohs surgeon treating patients in Northwest Florida. There are potential constructions of that in which she says, well, the Mohs surgeon is just a random piece of information. I'm an intellectual property attorney practicing in the Northwest Florida area, and when someone calls up and says, hey, I have an intellectual property problem, can you solve it? And I say, well, no, I'm doing criminal DUIs all of a sudden. We believe that most people reading that, it's a definite impression that's conveyed in the mind of a reader. And that impression is the kind of, is the information that when you consider also that it's a website. When one does a Google search, for example, for a Mohs surgeon, you don't get responses having to do with the NHL scores. You don't get information about the Antarctic ice shelf. You get information about Mohs surgeons in Pensacola. That does not require search engine optimization, as was referenced in the reply. That is just the natural language search that Google or any search engine does at this time. So by putting that information, she assured that someone looking for a Mohs surgeon through the internet in the Pensacola area would come up with her website. Maybe not on the first page, but certainly towards the top of that search.
But they'd still find it if it was not on the front page, because in her biography, She's got multiple references to it because that's a part of who she is. It's sort of like saying if someone has a certificate of antitrust specialization, they put it on their resume, they put it in their background, it's going to pop up in the web search too.
It is, but when someone goes ahead and clicks that link to the basic domain, they come up with Mohs surgeon treating patients in the Pensacola area. Most people at that point would feel reasonably confident that this is an individual practicing Mohs surgery.
Do you have any evidence on that?
No, it's
It's just argument.
It's argument. We don't believe that you necessarily need grammarians or a survey of individuals to make an argument about what the reasonable individual will interpret advertising to be. We believe it's a fair reading of the scope of what that website does.
And who printed out the website? I see now it says October 14th, 2015. Who created this document for presentation as a piece of evidence?
I'm not sure which individual within our firm, but it was attached to our motion. I'm not sure if it was collected by an outside source or by a paralegal. I just don't have that information, Your Honor. Because the public policy argument was never presented, because to claim entitlement for the additional time period requires an evidentiary presentation on Dr. Tarantola's part. The focus on whatever is inadequate in our evidentiary presentation is not the proper standard. She needs to present evidence that she didn't violate to claim affirmative credit. And for these reasons, we'd ask this court to affirm.
Thank you, counsel.
Thank you very much. That is argument about what pops up, things like that. This talking about search engine optimization and how it comes up in a search, this isn't the first time we've addressed this. I called the expert. I called in, and this is record evidence in front of the trial court judge. I called the person who created the website. His testimony was that there was no search engine optimization, and he called this a business card website. Much as you said resume, business card website is what it is. This doesn't go, you're not putting a website out there to advertise. Someone has to search for it and find you. They reference that you could send out a mailer. Well, the mailer is you write down somebody's address and you mail it to them. The internet, you cannot deselect where you're seeing it, and somebody has to go on there and affirmatively do something about it. It's not like a billboard that we had in the contempt. You're driving by, there's the billboard. Wow, here I am bringing you a message. It requires more. It's like a billboard with a curtain over it that you've got to walk up to and now pull the curtain open to see what's on there. That's what a website is. So all of this stuff, the evidence is contrary to what they're saying.
Is there any quantification of how many times your client performed the Mohs surgery in the restricted area during the limited?
There is no evidence of that in the record whatsoever, Your Honor.
That she did it all?
There is no record evidence about that, except my client saying that, look, I did at least a Mohs surgery on October 28th, 2015. And that's the date I'm using for the credit. And remember, we didn't start off with a 24-month deal. The court wrote, the court anticipates the case could last an additional 17 months. How did we get to a 17th month covenant? April, May, June, July, August, September, October. That's 7 months from 24 is 17 months. We started off with this October date as the basic time to do this. So when you're saying I have to come in and prove that stuff, that's how we started the injunction, was 17 months. The court then enforces the bond, doing a year and then extrapolating to 17 months for income. So those two things right there show that it was never supposed to be 24 months because there was an initial recognition of the credit that we have that was literally undisputed, and it remains evidentiarily undisputed. I put my client on the stand. She says October 12th when I start, October 28th for the first Mohs. Those dates comply exactly to what it is. That's why I filed the motion to terminate it in connection with all of this stuff. It is not my burden to prove the negative. I dispute that immensely. I showed that what it was. They had the chance to ask her all these questions and did not. With that, I don't think this order can stand. Thank you very much.
And thank you, counsels, for your respective oral arguments. We stand in recess.
All rise.